The Fourth Amendment to the U.S. Constitution reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched, and the persons or things to be seized." While law enforcement officers are entrusted with the power to do many things, for example search people and property, they must use these powers within set legal guidelines. However, there are cases of officers using their powers outside the law. Such was the case with Rodney King. After a traffic stop, King at one point was lying on the ground in an obviously submissive position, and was beaten by 4 officers of the LAPD. The following clip shows this, and be warned that it is extremely graphic.
Now the story that might never have surfaced if someone hadn't picked up his home video camera. We've all seen the pictures of Los Angeles police officers beating a man they had just pulled over. The city's police chief said today he will support criminal charges against some of the men. Here's ABC's Gary Shepard.
The 3 police officers facing felony criminal charges were among a group of 15 who stopped a 25-year-old black man last Saturday night, then beat him, kicked him, and clubbed him, unaware that an amateur photographer was recording the incident on videotape. Los Angeles Police Chief Daryl Gates looked at the tape and said he thinks assault with a deadly weapon will be one of the charges.
Essentially, the Fourth Amendment is the foundation for all United States citizens. As such, it must address various rights, liberties, and freedoms. Firstly, the Fourth Amendment establishes a privacy interest by recognizing the right of U.S. citizens to be secure in their persons, houses, papers, and effects. Second, it protects this privacy interest by prohibiting searches and seizures that are unreasonable or are not authorized by a warrant based upon probable cause. Third, it states that no warrant may be issued to a law enforcement officer unless that warrant describes with particularity the place to be searched and the persons or things to be seized.
Our last guest of the morning, Oren Kerr of George Washington University. He teaches at their law school there. And Mr. Kerr, the reason we brought you on, it was the Supreme Court heard a case concerning search warrants. Could you give us the setup, so to speak, as far as what the case deals with?
Yes, this is a case coming from Kentucky. It's about a drug arrest that occurred in an apartment building, and the issue is whether the police were allowed to enter the apartment without a search warrant. Now, a search warrant is a court order that a judge approves that says you're allowed to go enter into this place and search for evidence or arrest people, and the government had reason to think that there were crimes occurring inside the apartment, but they didn't have a search warrant. And the issue in the case was whether the police were allowed to search the apartment without the warrant, or whether they needed to stop, go get a warrant, and then come back and search the apartment at a later time.
So to step back, the police are chasing a criminal. Criminal goes into an apartment building and goes into one of 2 apartments, but the police don't know what happens or which apartment at the time.
That's correct.
Tell us what happens after that, though, as far as the door they knocked on.
So the police approach one of the apartments and they smell the odor of marijuana coming from the apartment. They had just had an undercover buy crack cocaine in the apartment building, and they didn't know if the person who'd sold the crack cocaine had gone into one apartment or the other. Turns out they picked the wrong apartment. The apartment where the odor of marijuana was coming from was a different apartment. They approached that apartment, though, banged on the door, announced, "We're the police," and then there's some testimony that they may have said that they demanded to be let inside, other testimony that they didn't. That's kind of uncertain. But they banged on the door and then heard a noise inside. At that point, the officers broke in through the door, searching on the theory that there was an emergency going on inside, what the Supreme Court has called exigent circumstances. So this is an established exception to the warrant requirement that says if there's some emergency, if there's some reason for the police that they can't wait to get a warrant, then they can enter. And one of the classic reasons for exigent circumstances is for the destruction of evidence. So what the police testified was that they thought the marijuana was going to be destroyed because the people inside, upon hearing the knock, were going to go destroy the evidence. And the issue is whether they were allowed to justify their search given that the noise that they heard was probably a response to their own knock. So the legal issue that the Supreme Court was playing with is whether there's a doctrine, and if so, what it looks like, of police-created exigent circumstances.
Because the Fourth Amendment can apply differently in different situations, we wanted to find out how it applied specifically to schools, so we interviewed School Police Officer Lafayette Webb.
My name is Officer Lafayette Webb. I'm with the Washoe County School District Police Department. I've been with the department 3 years, and I came from the Washoe County Sheriff's Office, where I spent 12 years working for SL.
All right. Do you believe the Fourth Amendment protects the people fairly?
I do, because it's not a black and white amendment, and I think they take into account all the variables that take place, because there's different, under the Fourth Amendment, there's different variables. For example, a school has different rights than, say, in your own home or in your vehicle and things like that. So I think it does take into account all the different variables in different places where the Fourth Amendment may be used.
All right. Another question, would you change anything about the Fourth Amendment? If so, why?
I would not, because once again, I think it encompasses pretty much everything, different situations. It's not a black and white amendment, but like I said, it's different from a school than in your own home, than your own vehicle, and it takes into account juveniles and certain things like that, so I would not change anything.
All right. Do you think it is fair to use evidence which was obtained without a warrant in a case?
Well, in some things, in some situations, a search warrant is not needed. For example, in plain view, if I see something in plain view, if I see a Jack Daniels bottle out of someone's backpack, well, that's in plain view, so I don't need a search warrant for. Schools, the courts have deemed it not necessary, that a search warrant is not needed. In Jersey versus TLO, it has made it so school administrators, all they need is reasonable suspicion. I still need probable cause. So basically, you don't need a search warrant in every situation. Like plain view, also open fields. Like if I see open fields across the street, obviously I can see it, so I can deal with the situation as opposed to obtaining a search warrant for that.
Okay. How are the Fourth Amendment rights different at school? I know you just sort of listed a few, but is there any other ones?
As far as, once again, at schools, I still need probable cause. Mm-hmm. So basically, I can't go into someone's locker just to be searching locker. If a student comes up to me and says, hey, I think my neighbor or someone has marijuana in their locker, that's not enough for me to have probable cause. Mm-hmm. What I could do is I could give that information, or have that student give the information to an administrator, such as Mr. Hackbush or Mr. Edwards. I can give them that information. Well, they just need reasonable suspicion. So they could have me work as an agent to search that locker, and I would search the locker, but it'd be under their reasonable suspicion. And the law that really applies to is Jersey versus TLO, which gives administrators more of a right to do things, whether it be a car on campus, a locker, or a backpack. I still need the probable cause, but they just need reasonable suspicion, and we don't need a search warrant for that.
A warrant is a legal document which must be approved by a judge, which states explicitly the place to be searched as well as the persons or objects to be searched and seized. If no warrant is provided, citizens may legally refuse to be searched to have their property searched. An exception is usually made in the case of hot pursuit if a criminal flees the scene of a crime and the police officer follows him or her. The officer has the right to enter a property in which the criminal has sought shelter without a warrant, but only to pursue and apprehend the suspect. If the suspect is apprehended and charged with the crime, the building may be searched only if it's the suspect's property.
In some cases, a warrant can be received to place a GPS on the suspect's property for surveillance purposes. Like a regular search warrant, this must be signed by a judge under reasonable suspicion, and must specifically state what is being monitored, when and how long it is being monitored, and what police are looking for. However, in some cases, police don't quite follow the specifications set by the warrant, as in the case of Antoine Jones. Jones was a main suspect in several alleged drug crimes in the Washington, D.C. area. In addition to placing him under visual surveillance and monitoring his phone calls, D.C. police received a warrant to install a GPS on a vehicle belonging to Jones's wife. The warrant stated the GPS must be placed within 10 days, and it could only be installed while the vehicle was in Washington, D.C. However, the police installed it 11 days after receiving the warrant, while the vehicle was in Maryland. Information from the GPS was used to convict Jones with numerous drug crimes of which he was suspected. However, the police did not follow the guidelines set by the warrant, which throws into question the validity of the conviction. This case is currently being considered by the United States Supreme Court. But what about other instances where one must submit to a search of possessions, like going through airport security? Because it's a voluntary service, the Fourth Amendment is still valid. Airports offer transportation which is much faster than any other widely available means. In order to use this service, one must go through security, customs, and many other similar measures which search you, your property, or both. While it may seem unconstitutional for airlines to require rigorous searches, one must remember it is a voluntary service they are offering, and nobody's forcing you through security. Every person has the right to turn around and leave to avoid the search, but he or she will not be able to fly should he or she choose to do so. Flying is a privilege, not a right. The Fourth Amendment forms what is perhaps the cornerstone of the rights of the U.S. citizen, but it is one that is taken advantage of or broken far too often. As such, we think it's important that all U.S. citizens know their rights when it comes to the Fourth Amendment. Thank you.